I'm joined in the conference room. I guess we could call it at the Bellagio Hotel. Kim Adams from Levin Law, one of the basically firms that run this conference and have for years. Kim, you're taking a case about essentially like a big porno conglomerate. Walk us through this.
Sure. So we filed a case a few years ago against MindGeek and their other affiliates. MindGeek runs the largest pornography site, or was at the time, Pornhub, along with RedTube and a lot of other websites or tube sites that they run. And so our case involved minors who were filmed at the time. They were minors at the time they were filmed, and their videos were exploited on these pornography sites. So that's kind of the basis of the case.
I just want to point out, I did a little bit of research on MindGeek. It is a Canadian multinational, basically pornographic conglomerate, owned by a Canadian private equity firm called Ethical Capital Partners.
Now, yes.
Oh, they've changed their name?
That purchase happened more recently than not.
Okay.
Right.
All right. Well, so just lay out for us, like, what is the legal action that one can take, and what is the responsibility that a publishing platform online has in terms of like what content is there?
Right. So I think that what gets interesting about any online case, right, is determining who's a publisher, who's not a publisher, a lot of the terminology from the legal perspective. But our allegations involve the fact that as an online platform, in this case, we allege that they created content that encouraged, facilitated, and helped disseminate child pornography. And so our causes of action involve both child pornography possession, dissemination, creation on the one hand, which is a statutory claim. On the other hand, it also involves Trafficking Victims Protection Act, which is a civil case for folks who and companies who facilitate and benefit from instances they knew or should have known to involve sex trafficking. So the trick is not really a trick, but with sex trafficking, minors cannot consent, right, to being sexually exploited. And so for our intents and purposes, minors are victims of sex trafficking. And when you have a pornography site that pays content partners, or who has, as we allege, no barriers to entry for exploiting those minors in videos and images and all of those sorts of things, that is trafficking of that minor. And so that's the basis of the allegation of our lawsuit is twofold.
Okay, so let's start with the trafficking part first. I mean, I remember interviewing an attorney here years ago who was they were suing a chain of motels or hotels that were aware that, or were not taking the steps necessary to make sure that there was no essentially child trafficking that was being done in the context of their hotels, right? And that's, you got to prove that they were aware of it and they were allowing it to happen and they're facilitating it. So there's an analogy there, I guess, on some level. But what is the relationship between MindGeek and the, for lack of a better term, the contractors who create this content? So do you need to, how much of a connection do you need to make there?
So I think the threshold is knew or should have known, right? They don't have to have actual knowledge. They knew or should have known these things were happening. How could they have known? Both in the hotel context as well as the online context, they know who their they know who their users are, right? And on MindGeek's platform, you have almost, as we would allege, a heightened responsibility because you're running a pornography site. So you have at least a responsibility to make sure that the people in the videos, the images are not minors. When you talk
So
about
is this
having
user content? I mean, theoretically, user content as opposed to MindGeek commissioning people?
Well, I think it's both because MindGeek creates the platform, they create the rules, they create thumbnails, they create algorithms, they create the things that help facilitate a minor. If you're creating a thumbnail for every single, as we would allege, every single video or image that comes to your site, and your program is creating what's going to be the hottest search term, or you're creating what is the hottest image that's going to be looked at, or where the activity is happening within the video, then you're creating content. So it's not really, maybe the user supported the content originally, right? But MindGeek's creating its own content. And so I think that's where the difference
Is this, I mean, is this analogous to like what that YouTube services provide in terms of like that relationship? Because I wonder how close we're getting to like a Section 230 type of case here.
Yeah, well, it's all about Section 230, right? So in YouTube,
All right, we should tell us about Section 230 because there's been a big TikTok case that happened, I think, like 2 months ago, and that has completely changed at least the dynamic, and it really was a function of the Supreme Court almost being hung by its own petard in terms of what they had said in a case about censoring or social media. But walk us through, what is Section 230?
Sure, I'll do that. And let's just say, let's, to be clear, child pornography is not protected speech, right? So we need to be very clear, I think, about what we're talking about when it comes to protecting children. With Section 230 is an immunity statute, and it was created years and years and decades ago, right? And it was
Telecommunications Act.
That's right.
Telecommunications
Correct.
Act of 96.
It was an effort to facilitate online providers, right? The internet was exploding, so they wanted a way to protect those people. And at that point, people were simply posting things, and you had platforms that supported it.
Right. It's a platform versus a publisher was sort of the vague distinction, right?
It's a I think that's fair. At least it was at that time, right? And so now I think it has turned into facilitating money. Before, you might have had an ad on there and you had no control over what that ad was doing. That's not the case anymore, right? If Pornhub, as we would allege, has its material on there, Pornhub is going to bring in marketers that are tracking categories they create, terms they create, algorithms that they create. Now, there is a circuit split in the federal bench on whether or not algorithms bust through immunity or not, right? We don't know if you're entitled to immunity. I think the U.S. Supreme Court heard the Google v. Gonzalez case, which was all about YouTube. And the Supreme Court punted the question. And I think that when the right case gets there, there will probably be a reworking of Section 230. You see,
and
often,
just to be clear, circuit split means that one of 13 circuits has ruled one way, another the 13 circuits has ruled another way. That conflict, the law of the land is literally different depending on which circuit you're in, and what other circuits sort of use as the circuit that they're going to follow. But in those instances, the Supreme Court feels more pressure to take the case.
Right. And what facts, right, support that. So I didn't clarify on Section 230. You asked me about 230. And so 230 is an immunity statute that says any platform that is just a publisher is being looked at as a publisher of third-party content. So if Sam wants to write an article, Kim wants to write an article, and you publish that the platform owner should not be touted with policing what a third party is developing.
Right. So if I have a blog, for instance, with comments,
right,
that I'm not responsible for what people write in those comments.
That was the intent of 230, was to immunize those folks. What cases that you're seeing now is they're almost creating products within themselves, right? And because those products are being created, plaintiffs are arguing that you should not immunize people who are exploiting children intentionally. Or not,
just to use my blog analogy, I'm allowing comments, but I've also devised ways of pushing certain comments to the top. And I've also devised ways to send ads to people who write certain types of comments.
Right.
And I'm actually directing people's attention to different places on my now much more sophisticated blog, which is now maybe almost a social media platform. And in that, embedded in that, I'm making content, and that pushes me into the realm of a publisher of sorts.
I don't know that I would agree with that, but we can certainly have that discussion. I think that it could, right? And it probably could, so long as you don't have illegal content on your site. And I think that the difference here is the conduct we allege is so egregious on these website platforms that are exploiting children, all of your social media platforms, that I think legislation and the court systems want to put a stop to it.
Right. So this goes beyond 230 into a realm where this is not, there's actually a whole separate, distinct set of law associated with child pornography.
Yes, there is that pillar. However, what we allege is that 230 does not apply, A, because they're creating content. If you're creating content, 230 does not apply to you. Or B, if you, let's say the court doesn't agree with us, we would then go into some of the fixes that they've tried to do with 230 with like, there's another legislative statute that says, okay, well, we're going to let you sue a website platform owner, but your conduct has to rise to the level almost of like criminal conduct or intentional conduct. But we have those allegations in some of these cases, which you don't always have with other content providers, if you will. So I think that what we have seen, at least in our case, on the MindGeek case, we won the motion to dismiss, and that's just what we allege versus what the defendants allege. The court said, yes, there's enough information here to move forward. I'm not going to dismiss the case based on MindGeek's allegation that they are a hosting provider, but certainly that's what they want to be, right? We're just a content hosting provider. And so the court, at least at that stage, said, no, we're not agreeing with that. The court also certified our class action, which was essentially saying that the scope of our class is anyone who is a minor under the age of 18 at the time of video or image was produced, and was that video or content was made available for viewing to the open public on those platforms is a potential member of this class. So the court certified that class for anyone who fits into that. And so now our next phase will be putting out notice. So we've done those things, and then we will have to go to trial to see, does the jury actually agree with us? Is the jury going to agree that the facts show that they created content? Does the jury agree that the facts show that they acted intentionally or with malice, reckless malice, malice disregard, or does the jury believe that in and of itself they were disseminating, possessing, and distributing child pornography? So those things will still have to come to a jury unless something else happens with the case. But right now we've hit all the marks, and our next step would be summary judgment. And that's where the court looks at all the facts that have come in and decides if there is a question of fact from both sides, the court won't issue a summary judgment order. It will go to a jury. The court could look at all the facts and say, it will be impossible for a jury to see this case some other way than the way that the plaintiffs are alleged it or the way the defendants have alleged it, and could make a ruling. So
it's basically saying, like, here are the facts. We don't need to adjudicate them.
That's correct.
And the judge is capable of adjudicating the law in this instance.
That's right.
How many plaintiffs do you have at this point?
So there are hundreds of plaintiffs that fit into this bucket. With regard to how many potential class members, there are thousands of class members that fit into this. And upon our estimation and assumptions.
In terms of that first motion that the court dismissed, the idea is that essentially, like, we don't operate, we're not a content provider, we're just a content hoster, essentially. That seems like a big ruling in terms of like building the building blocks for a future verdict against the defendants, right? Because that seems to be their number one defense.
It is. So yes, if the court ruled in any case that Section 230 immunity does not apply to them, then absolutely. What you're seeing on TikTok, Snapchat, some of those other cases, is creative allegations also. They're saying that this is a product liability case. Section 230 doesn't even apply whether they created content or not. They created an app or a program or a product within their platform. And so now you're looking at product liability law. You're not looking at trafficking law. You're not looking at child pornography dissemination, those laws. You're looking at product liability law, like what we're here at this conference talking about.
I see. But my understanding is that TikTok case, the one that was brought by, I think, parents of a child who killed herself accidentally by doing something that on TikTok was like the rage. That there was that the court said, citing the Supreme Court in that other case of whether you could censor political thought or whatnot on the social platforms, and they said you can't make us censor political thought because we have a First Amendment right here because we're doing expression. In this subsequent case that they determined, well, if you have a First Amendment right, then you are exercising speech. And if your platform is exercising speech, you're not just a host, you're a publisher.
Yeah.
But that's not implicated in your case.
No, it's not. And I think hosting versus publishing, I view those almost as the same. Right. If you're hosting content or publishing content, you're hosting content that you are acting as a publisher to evaluate. So I view those as the same sort of, or similar at least, as opposed to creating content where, and I'm not overly familiar with the TikTok case.
Okay.
Yeah.
Okay. And so in this instance, Pornhub or whatever these outfits, they're actually creating the pornography.
That's our allegation, is that well, if you're creating even a thumbnail of child pornography, you're creating content. You don't have to create the actual content. You have to materially contribute to the illegality of the content that's out there.
I see. And so what's the timing for the next phase?
So
how do you reach members of this class action? Because I would imagine that if you have been subject to this type of abuse, I think in some instances, maybe there was a certain amount of suppression. In some instances, you may not even realize that it was like illegal and abuse. And certainly there's a cohort of people who are like, how am I going to hear about a class action suit?
Right. So to answer your first question, we're almost finished with the summary judgment briefing. So that will be happening in October. With regard to how people are noticing, on some of our public filings, you'll see that we will put notices on the websites the court has ordered. We will talk to different or trafficking victim protection organizations, social media notice, other kind of publications, radio, those kinds of things. And so that notice is going out, and they have until, I want to say, December to opt out of the class if they don't want to participate.
I see. And then in these instances, essentially your class action will allow people who, even if they find out about it later, will be able to recoup some type of compensation or whatnot, but they will not be able to pursue their own case similar to this one
unless they exclude themselves from the class. Correct. They will be subject to the rulings by the court in the class action. So if the court rules against us, let's say, then it would rule against all class members unless they have opted out of the class.
Have you guys entered discovery yet?
Oh, yes.
And so I imagine there's only a certain amount of stuff that you can talk about, but have you found, characterize what you found there in terms of the people who were running MindGeek at the time?
So I guess the only thing I can say about that is there's a lot of public articles where the heads of those organizations have written very publicly about how they feel about the case and how they feel about those things that are going. I can't speak to kind of what the discovery actually showed, but I think that when you go onto the public viewing platforms, you can kind of see how they feel about it. So we feel like our case is very well supported. Our allegations are very well supported. I think that, you know, the Canadian folks that run these platforms are not necessarily, weren't, I should say. I don't know the new folks. And I'm hopeful that because of these actions, that all of the social media and pornography sites are doing a better job at protecting the youth. So I'll just say that. And I'm hopeful that whoever the owner is and whatever the owners are doing at this point, that they're making every single effort they can to block children from being exploited on their site. They control those powers, right? So
It's amazing because I know this was like an issue 30 years ago. The late Barry Crimmins, a comedian from Boston, testified in front of Congress about what was happening on AOL's platform with this stuff. It's amazing that this still goes on in such, you know, such a commercial, like public facing enterprise.
it is amazing, and it's very sad. We have to do more for our kids.
Kim Adams from Levin Papantonio, a law firm. Thank you so much for your time today.
Thank
Really
you.
appreciate it.
Appreciate it.
Hey folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.